Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Hi, and welcome to the podcast. Glad you could join us. I wanted to speak to you today about what happens in a litigated matter and the zealous advocacy concept in a litigated matter balanced with wise counsel in private. And my practice, I typically spend a great deal of time in court, and about 80% of the cases that we do are contested matters in probate court. Trust and estate contests of all kinds, will contests, trust contests, breach of fiduciary duty claims, things of that nature, contested conservatorships as well. And it's often very helpful for the client to understand how it is best to proceed in both demeanor and approach in court with respect to a litigated matter. Now, it's a little bit philosophical, and I don't want any of this to sound self-serving. I've been in practice for coming on 32 years, and about 20 years of that has been in the arena of trust and estate litigation in probate court. And I can always tell everybody that I learn something new every day. Every day you go to court, every day you're practicing. Love the practice of law, but you're always learning something new every day. I guess that's why they call it the practice of law, because you're always practicing it. But one of the things that I think is important for people to understand that when you go to court is that zealous advocacy has to be bounded by civility and also bounded by a wise approach to the court with respect to a couple of concepts. One of the things that we pride ourselves at this law office is that we always try to put forth our best work product, best written work product right at the front end of the case. And we do so by clearly identifying the issues that confront the client, understand and know the rules, both statutory and as they are set forth in California case law with respect to those issues. Then be able to conduct an appropriate analysis of the facts of the case to comport with those rules, to reach an ultimate conclusion that is beneficial to the client. Now, nothing about this podcast is legal advice to you now. If you need to call us about anything, you may. If you need to speak with an attorney because you're facing a particular matter in probate court, reach out to your attorney. We're happy to receive your call and give you a consultation. But it's very important at the outset of the case, any litigated matter, to understand that when you go to court, it's not about bombastically arguing against the other side. It's not about putting somebody down. It's about doing zealous advocacy in a way that comports with what the court expects counsel, how they expect counsel to behave. Now, what do I mean by zealous advocacy? Well, definition of zealous means, I'm reading it right here, showing great energy or enthusiasm in pursuit of a cause or objective. And that's certainly what we try to do. Try to do that with every case. And we have specific rules that we must follow with respect to how we apply our zealous advocacy. There's Rule 1.3 of the California Rules of Professional Conduct that states that a lawyer shall not intentionally, repeatedly, recklessly, or with gross negligence fail to act with reasonable diligence in representing a client. So we're charged as lawyers to reasonably and with reasonable diligence represent your interests, represent the interests of the clients. And reasonable diligence under the rule means that the lawyers acts with commitment and dedication to the interests of the client and does not neglect or disregard or unduly delay a legal matter entrusted to the lawyer. Okay, that's pretty clear. We understand that we have to do that. Now, how is that applied? How is zealous advocacy applied in a litigated matter? Well, California case law has some things to say about that. There's a case called Hawk v. Superior Court. For those of you out there that are looking for a citation, that's 1974, 42 Calap, second 108, 126. I think I've got that one right. And that's the duty of a lawyer states that the duty of a lawyer, both to his client and to the legal system, is to represent his client zealously within the bounds of the law. So zealous advocacy means that we're supposed to represent the client within the bounds of the law. And what is the law that we have to follow in zealous advocacy? Well, California Business and Professions Code says, that's in 6068, that it is the duty of an attorney to do all of the following: to support the Constitution and laws of the United States and of this state. Okay, so first instance, we have to obey the law when we're zealously advocating for our client in court. Right after that, 6068B, we must, quote, maintain the respect due to the courts of justice and judicial officers. So when you go to court, got to be on your best behavior. You want to present to the court well, always try to do that. Want to be prepared, want to make sure that you know what the issues are in the pleadings against your client or the pleadings that you're advancing for your client. You know what the issues are. You have some comprehensive knowledge of the rules that apply to that, and you're ready and willing and able, through your briefs and in oral argument, to conduct an appropriate analysis before the judge in discussing those matters. Typically, a case starts off at the pleading stage. Someone files a petition, which is the equivalent of a complaint in civil court. And then if you're defending it, you file your answer, or what we would call an objection or a response. And at the first hearing, when those things are filed, you'll have a discussion with the court where the judge is not going to decide things at the morning calendar in probate court. They'll typically understand that the matter is at issue. Maybe some certain things will get resolved, but generally speaking, if there is a contested matter, that's going to have to await the discovery process, and it's going to have to be put on in a contested hearing or trial where the judge, who is the trier of fact in probate court, the one who hears the evidence and decides the fate of your case, will receive testimony from witnesses that testify in court and also receive all the documentary evidence that might be admitted through proper evidentiary procedures to get those items into evidence. So you must, in all circumstances, pursue the case with diligence, pursue the case. We have to do that for you. But we have to do it in a way that is respectful of the court, respectful of the judge, respectful of the legal process, and indeed respectful of your opposing counsel. Doesn't mean you don't get into vigorous arguments, doesn't mean you don't have debates on the record, but you do have to mind your manners and mind your P's and Q's when you're in court. And it's the best thing to do for your case. It's the best way to build credibility for you, for your case. So being a zealous advocate is not going down to the courthouse and making bombastic arguments or attacking people or making personal attacks or being unruly or aggressive to opposing counsel. It's almost never like that. Sometimes things get a little bit heated, but generally speaking, composure should be the order of the day. And good lawyers, we think, we always try to be good lawyers for you. We live by that. Got a little note here from the California Lawyers Association, which is a member-driven, mission-focused organization in California that is a voluntary bar association advocating on behalf of members of the bar before the legislature and the judiciary and the executive branch of the State Bar of California. And the State Bar of California is the licensing and disciplinary regulator of our profession. And the California Lawyers Association reminds all counsel, regardless of your practice area, regardless of your age, regardless of who you are, what walk of life in practice that you have, that zealous advocacy does not equate with being an attack dog type of person or scorched earth. And it doesn't mean a lack of civility. And in my practice of up to 32 years, I have found that you'll get less results doing those things than you will by going in prepared with knowledge, knowing the case, knowing what the issues are, and knowing what the rules are in both statute and case law. And I think it's important for prospective clients who are not used to the legal system to understand that. It's not like what we might see on television or anything like that. It's a little bit more different. It can be a very intellectual discourse with the judge about uh, uh, discussions on points of law that might seem very boring when you're sitting there next to your lawyer at the counsel table at the first couple of hearings or at any motion work that he may invite you to attend to. And I always invite my clients to come to every hearing that they want to come to when I appear live before the judge at every hearing. So definitely you want to be zealous, but you want to be zealous in a way that shows strength. And strength comes from knowledge, and it comes from keeping the rules and knowing where the rules of law that apply to a particular case are, and being able to apply those in an appropriate way toward the appropriate conclusion, whether that's through law and motion work to resolve a case such as by procedural vehicles like a motion for judgment on the pleadings or a motion for summary judgment. If you have enough law on your side that you can eliminate an issue by a motion for summary judgment or a motion for summary adjudication, or you are prepared at the successive hearings that you're going to court with your client over their matter to address the court if the court suggests that this matter should go to mediation. A mediated result before a neutral mediator is often the best result. It can cut out a lot of attorney's fees. It can be a quicker disposition of a case where both sides might not exactly get what they want, but they are getting something that they've agreed to, and they are getting something that is certain. And that settlement agreement can become a court order, and the case can be resolved and spare a lot of time and money and curb risk of not prevailing. If you go to trial, you don't know necessarily. You might think you have a slam dunk case, but it might not work out that you have that, and no lawyer can give you a blanket guarantee as to what they can deliver to you in court through trial. Or if it doesn't work out that you can mediate the case and law and motion is not available to you to decide the case, you do go to trial. And we go to trial with some great frequency when those other avenues are not available to us. And all of it really depends on making sure that you know what the issues are, what the rules are, what the appropriate analysis is, and what the reasonable conclusion is going to be for your case. For example, let's say you have a case where it's alleged that undue influence was applied against an elder in the preparation of a particular document. Well, what does the California case law say about undue influence? Many times I'm in court and people are alleging facts of influence that they claim to be undue influence, but it is not undue influence. It is when we're on the receiving end of some of these allegations, we can see how we can defend against them, because people will construe something as being undue influence, and it's not even any influence at all. It might be just a mere conversation that a child had with a parent about a prospective inheritance or something like that, that doesn't rise to the level of undue influence. And I see it enough from on the receiving end and on the other side, such that I wonder sometimes if people are maybe counsel, it's always good for counsel to bone up on the case law when they go to court to make sure they know what they're talking about and they know what positions they're advancing. As to that particular issue, one of the rules that the California Supreme Court has defined with respect to undue influence is it's pressure brought to bear directly in the case of a will or trust contest, where you're contesting the whether or not somebody did something of their own free will. It is, quote, pressure brought to bear directly on the testamentary act sufficient to overcome the testator's free will, amounting in effect to coercion, destroying the testator's free agency. That case is Rice v. Clark, 2002, 28 Cal 4th, 89. And so what does that mean? Well, that means that undue influence isn't just any old influence. It's not suggesting something to mom or dad that you might like to have and having brothers say, you're unduly influencing mom or dad, or having a discussion with them. Depends on the mental state of the person that they're talking to. But we'll get to that in a moment. But undue influence, the rule with respect to undue influence that you want to understand if you're going into court right on the first day on an undue influence case is to directly understand that it has to be coercive pressure that basically destroys the testator, the person who's making the will, or the trust, or the person who's making the trust. It destroys their free will and basically replaces it with the perpetrator of the unduly influential act. Now, a lot of people don't understand that when they may think they have a case, and come to the office and we patiently and usually in fairly ample free consultations, we'll discuss that with them so that they understand that the threshold for undue influence is it's not an unreasonably high threshold, but it's up there. It's you have to make sure that the person isn't just your brother or sister complaining to mom or dad that they need to have this or they need to have that. That probably won't cut it as undue influence. It has to be something that destroys the testators, destroys mom or dad's free agency, such that they give up or are completely incapable of resisting it and just cave in and basically effectively scrawl the undue influencer is effectively writing the disposition for them in effect. I don't want to overstate that too much, but that's kind of what you're looking at when you're talking about undue influence cases. And that's important to know when you go to court so that you don't have counsel or anybody yourself have an understanding that it's somehow a lesser standard that you can't prove because it simply isn't undue influence. It doesn't meet your issue, doesn't meet the rule, such that when you do the analysis that you will, the trier of fact will conclude that undue influence was obtained. Another one that happens quite often is we get a lot of cases where people will say, mom or dad or grandpa or grandma or grandpa didn't have requisite capacity to execute a will or a trust because they were old and they had dementia, or they had frequently thrown around term that is of ambiguous sometimes definition. And the law provides some guidance as to what the rules are, obviously, with respect to capacity to make a will or a trust. Citing to a case called Anderson v. Hunt, 2011 case 196 Cal App 4th 722, where the court reviewed the state of the law as it had evolved and still exists with respect to how much capacity does a person need to execute what I'm going to talk about now, a simple will or trust. What is the rule? What is the rule that you want to know about before you go in with a lack of capacity case? And the case law states, and this is where Anderson v. Hunt is citing to a string of other cases within Anderson v. Hunt. And it states, it is well established that old age or forgetfulness, eccentricities, or mental feebleness or confusion at various times of a party making a will are not enough in themselves to warrant a holding that the testator lacked testamentary capacity. And there's a myriad of cases that say that thing. So let's say your complaint is that, well, grandma's in her mid 80s and she's been diagnosed with some cognitive difficulties and even has the onset of what we would Alzheimer's or something like some cognitive difficulties in her neurocognitive uh, mind, her state of being with respect to her ability to comprehend and understand. She's got a condition that might affect that. The mere fact that she has the condition doesn't mean that at the moment she puts pen to paper on a will, a little bit different with a trust, higher standard. It doesn't mean that she can't do it. If she's working with a lawyer who's patiently explaining the ramifications of her testamentary acts and she understands all those things at that time, then her eccentricities and her feebleness at other parts of the day and other times in her life might not matter at all. And there's ample case law that specifically states that a lawyer's testimony as to their own client's capacity to execute a will is entitled to great weight. And in my experience, I've seen where that could even trump the opinions of a doctor in a given circumstance. So I get back to it. What is zealous advocacy? I think zealous advocacy is knowing what the rules are. Zealous advocacy is knowing what the statutes have to say about the issues that you are confronting in a action you are bringing against someone else or an action that they are bringing against you. And then while we'll go to court and we'll follow instructions and do the absolute very best we can for our very valued clients, we need to be able to speak with you with that wise counsel in private part where we could say, here are what the rules are. Here's what our experience with a particular judge might be. Here is how these things might often play out in terms of how the evidence will come in or not come in, so that the client can make decisions that are good for them and that are not based on emotion, which always comes into cases, and you can't separate it. You can't get rid of all emotion out of any litigated matter. It's going to exist. But you want to be able to ground your case in the rule of law, the rule of the statutes that control a particular area, which are quite extensive in California probate code, which governs probate matters and trust and estate matters. And you want to be able to patiently enable your lawyer to write about those things and communicate those things so that the judge understands that your counsel knows what he's talking about, knows what he or she is talking about, and is thereby building credibility for your position. That doesn't have to be done with a lot of histrionics or waving the arms or argument or nasty letters or any of those kinds of things. It's usually done by careful, deliberate, plodding, hard work, and deliberate focus on the evidence, the transactions that are being challenged, and the medical records that will show where a person might be with respect to their cognitive abilities at any given point in time. I thought that would be, this is very important when people come to the office. We consult with people quite frequently. We do give ample no-charge consultations when we are able to do so. And I'm always very, I like to think, very diligent, even before I'm retained, in making sure that people understand the rules of the road as they're going forward and what we must do and how we must comport ourselves in court before the judge on every case that we bring before that judge. Important thing to know about probate court, probate code section 825, is that in most probate cases, you don't have a right to a jury trial. The person that you're going to see in court, the judge, the first hearing when the petitions are being reviewed at the first hearing on a matter, which was basically a form of status conference, he or she is ultimately going to be your trier of fact. What is a trier of fact? Well, a trier of fact is a person who would decide your case. In the case of a jury trial, it's a jury. In probate court, in overwhelming number of cases, because the statutes say you don't have a right to a jury trial in probate court, it's going to be that judge. So when you go to court, if you go to court by yourself in pro per, or if you go to court with your lawyer, you always want to make sure that the person you're approaching the first time on the case and the second time on the case and in all the ensuing proceedings in the case, you deal with the court the way the rules of professional conduct and the business and profession code commands us to behave, which is with respect, with diligence, with passion, for certainly, be as articulate as you possibly can. Listen to the judge. The judge is done hearing you speak and it says he's had enough. It's a good time to be quiet, and always inquire of the judge what you can do to facilitate his knowledge as you move forward in the case. That's the best way to approach zealous advocacy. Zealous advocacy is wise advocacy, restrained, contained, but forceful in its knowledge and application of knowledge. I like to think after 32 years at Bochnewich Law Offices, that's what you'll get if you come to us. I do know that that's what most of my colleagues strive to achieve. And there are many good lawyers in the area that I practice in that do the same thing. But it's very important, I think, for people when they're in the uncharted territory of a new case, someone suing them because or for breach of fiduciary duty and handing mom's trust, or for undue influence, or any of those things, or someone feels that they have to bring that action against someone because of something that happened. And there's a lot of emotion. There's a lot of anxiety about what's going to happen. And that's not going to be taken away by any sort of bombastic approach or overly aggressive approach that's caught up in a lot of words that don't mean anything. If you're not grounded in the law, you've got to be grounded in the law. You want your lawyer to be able to spot the issues for you day one, take you through it, come up with a plan, apply the facts to the law, and be able to articulate with reasonable probabilities how your case is going to play out on the evidence and move forward that way. There's probably no reason for me in having an intellectual conversation in court with opposing counsel or a judge to speak any louder than I'm speaking in this video right now, and hopefully convey the sense that we've studied the issue. We know the rules. We know what the case law says. We know what the most recent case law says. We've been in enough situations, so we know how it's likely going to play out. Can't predict it with 100% accuracy at all. Can't give a guaranteed result. No lawyer can do that. As a matter of fact, we're not supposed to do that. But we can give you the best framework by which you, the client, can make wise decisions about how you're going to spend your litigation dollar, how long this is going to take, whether on all things considered, you're willing to go to maybe achieve a mediated result. I thought that would be very helpful. I took a break a little bit from the usual academic podcasts that we've been doing to discuss this with the prospective client out there, or people who might be looking for a lawyer anywhere and want to know what's kind of approach that's the best approach. I think the best approach is zealous advocacy in court, absolutely grounded in understanding the issues, knowing the rules, doing the appropriate analysis to reach an appropriate conclusion, and wise counsel in private about what all that means, so you, the client, can make the best decision for your case possible. And that's all I have to say for today. And I'm glad that you could join me, and we'll see you next time on Your Inheritance.
You've been tuning in to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. If you're being sued over an estate, or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.